We have about 139 people registered for today's session, but in the interest of time and to give Kim enough time for her presentation, I think we'll get started. We'll continue to have people joining, obviously, for the next little bit. But I'd like to officially welcome you all to the Occupational Health and Safety Collaborative Forum. My name is Dana Loeppky, and I'm the Executive Director with the Continuing Care and Safety Association. This forum is presented in collaboration with the Alberta Seniors and Community Housing Association, as well as the Alberta Continuing Care Association. So before we get started, I'd like to do a land acknowledgement. So we acknowledge the lands we share with the original people, including the many First Nations, Métis, the Inuit, and all other ancestors who made this land their home. As we gather within these territories, we are grateful for all that sustains us and provides for us at this time. We're thankful for the new beginnings, new life, and opportunities. In the essence of reconciliation, we acknowledge these territorial lands of Treaties 6, 7, and 8. So before we move on to Kim's presentation, just want to remind everyone, in the interest of the best experience for everyone, if you could please keep your mics muted and put your raise your hand or put a question in the chat. And then if you're comfortable, you can unmute and turn your video on and ask any questions that you might have either throughout the presentation or at the end of the presentation. So without further ado, I would like to welcome Kim Bartch, who is an industry specialist with WCB. She has been with WCB for 12 years and has been an industry specialist for the past couple of years. The industries she works with include continuing care, municipalities, not-for-profit, and some retail. So welcome, Kim. I'll stop sharing and I will give you the space to share your presentation.
Thanks, Dana. Thanks for having me. I also have a coworker, Martine, with me as well, so she'll be helping moderate throughout as well. So yeah, thank you. I think it looks all good there.
Yep, perfect, Kim.
Okay. So yeah, today what I'm going to be going over is just some information about our request for review process and our appeal system. So if there's ever been a claims decision that you've seen come across your desk as an employer, manager, whatever your role is, at your place of employment, you'll hopefully have a better understanding of how to go about the process if you don't understand the decision or if you want to request an appeal or a review of that decision that's been made. As we do, if you've ever attended any of our seminars that we host online the last few years, we always go through these principles and key features of WCB. They're really important. So I'll start off with these. We are a no-fault insurance company. So that just means when we're looking at adjudicating claims or looking at whether something's acceptable or not, we don't look at who was at fault at causing that accident. So if a worker maybe wasn't wearing the proper protective equipment, sustained an injury, that doesn't come into account with our decision. Same as if some equipment was faulty that the employer was negligent at keeping up to safe working order, we don't take that into consideration when we're making our decision. With the no fault, in exchange, I guess, for that no fault protection or no fault coverage, employers are protected from lawsuits. So that means if a claim is accepted under WCB, the worker can't sue their employer for being negligent and causing their injury. So that's under whatever falls under the Workers' Compensation Act there, you'd be protected from lawsuit there. We also have a clause in our policy where benefit of the doubt goes to the worker. So when we look at, you'll see going through here, I'll talk about kind of weight of evidence and standard of proof, those types of things when we're looking at what's an acceptable claim. If evidence is equal on either side, so if we have all the information from the worker about what happened to them, we have our medical reporting, we have information from the employer. If it kind of is on the scale and it's balanced, it's equal, we could go either way with the decision. Benefit of the doubt will apply and we will accept that claim. The benefit will go to the worker. Workers and employers both have the right to review and appeal decisions on the claim. So for employers, we're talking about any claims decision that's made, as well as an account decision. So if there's decisions made on your account side with regards to what industry you're classified in, if you don't think that that's the right one, you want to appeal that decision, or if we've combined a couple accounts and you don't think that that should have happened, those are decisions made on the account side. You can appeal those as well. We are exclusive jurisdiction, so we are the only workers' compensation board in the province. We don't have any competitors, so it's just us that you have to deal with. So I don't know if, hopefully this is mostly good experiences, but we are based on legislation. So the government in place at the time will direct what our policies are, or direct what the Workers' Compensation Act says. They will make changes to that, or put in additional clauses, and then we base our policies off of that legislation. So we are the neutral administrators of the Workers' Compensation Act. We don't come up with this stuff all on our own. It is based on what the legislation says. And of course, our main goal at WCB is to support Albertans in that safe and healthy return to work as safely and quickly as possible from their workplace injuries and illnesses. All of these too, I should mention, at the bottom of the slide, you'll see blue text. Those are just links to where you can find this information on our website. So we do have a policy manual available where you can follow along if you want as we're going through. Today, as I said earlier, we're going to focus on questioning claims decisions that have been made, not so much the account side of things, but more so the claim side. So what does that request for review look like? You could be requesting the initial entitlement decision on a claim. So you're not understanding or don't agree that this claim should have been accepted. There could also be decisions made. Maybe you agree, yes, this is an acceptable work-related claim, but you don't think there should have been wage loss benefits paid on that. You don't agree with that decision. So there's lots of decisions, multiple decisions that happen throughout the life of a claim, and every decision is appealable on the claim. We're going to go through that, the different levels of appeal, and also how to prepare for and participate in the appeals process. So there's different levels and different stages. And after this, hopefully you'll feel more comfortable with, if you request a copy of the claim file, how to organize that in the best way, what things you should be looking for, where to find the policy so you can match up, okay, here's the decision they made with the policy, kind of make sense of all that stuff. And any questions, like Dana said, put them in the chat, put your hand up. Our team will be watching for those in the chat. And also I assume we'll get some assistance from Dana as well if we miss one or two. When we're making our decisions, and when I'm talking about I'm talking about our claim owners. So we have adjudicators that work for us who are, they're the first people that get a hold of the claim when we're looking at if it's acceptable or not. So they're the ones that are going to be gathering all that information, weighing the evidence, talking to both the employer and the worker, gathering that medical to say, is this an acceptable work-related claim? They'll be making that initial entitlement decision. We also have case managers that work for us. So they take over the claim after, for more of our longer term injuries. If a worker's not back to work after 3 months, I believe it is now, they've extended the time frame that it sits with an adjudicator now. But case managers handle more of our complex claims and longer term claims. They don't make the initial entitlement decisions, but they would be making decisions about, suitability of modified work, home maintenance allowance if someone has a permanent injury and they can't do stuff around the house and we need to give them a supplement to help them with that. There's multiple different decisions. They're going to be looking at basing their decisions on that Workers' Compensation Act, as well as our policies, which are again based on that act. We're going to look at what is the standard of proof. So this is what the standard is in civil law. We're not criminal case law here. We're not looking at beyond a reasonable doubt. We're not going to ask either side to prove 100% that something happened or not, but we're going to weigh the evidence. We're going to balance the probabilities in order to determine our entitlement decision. And based on the weight of the evidence, we want to resolve if there's any missing information. We're going to be requesting that for you and hoping if based on the conversations you're having with those adjudicators, that you can provide any additional information at the time before the decision is made. That would help with making that decision. We're going to weigh that evidence and base our decisions on that. If there are any conflicts along the way with the information that we receive, we do want to resolve that conflict. We're not just going to make the decision and leave that aside. So if you bring up any concerns, if the worker does, or if there's a conflict of medical opinion, we do have ways to resolve that conflict as when we go through. I'll talk about that a little bit more. Things that can't be appealed, we'll talk about that first. So if you have any issues about the management of your claims management, so any issues with the adjudicator, case managers, this is something that we're hoping that you can have a conversation with them first and try to resolve it. If not, talk to their supervisor. If that doesn't go anywhere, we do have a fairness review process now that you can request. If you just go on our website and look up the fairness review process, you can actually go through and talk about that a little bit further. We have another department that deals with that. So if it's a process thing, you don't feel like that the case manager or adjudicator followed our processes as we normally do, they maybe skipped a few steps, or if they weren't treating you fairly, if any of that is happening, hopefully not. But if that happens and you can't get it resolved at the supervisor level, you can ask for a fairness review as well. So we all want to be cooperating together, collaborating in this plan. We all want to be talking respectively to each other. And hopefully that all goes smoothly when you deal with us with your claims. You can't request a review of your premium rate. So that is set every year by our underwriting department. You can appeal what that is. Also your experience rating. So what that is this is how we determine what premiums you pay. So we compare your costs to the industry average for costs. If your costs are higher, you might get a surcharge on your premium. If your costs are lower, you'll get a discount. If you're in that surcharge position, you're like, I don't like this, I'm going to appeal this rating. You can't do that. The best way is to take a look at the claims that you've had accepted in that period of time. Is there any decisions that maybe you can get overturned there if you think there's any decisions that you don't agree with, or if there's cost relief available? I mean, I can go on. I should maybe realize I only have an hour. I can go on about certain things, but we do talk about this in more detail in our 3-hour seminar that we talk about appeals. But yeah, you can appeal your experience rating. Policies and legislation as well. You can appeal that through us. If you have any concerns with the policies, we do have a policy consultation process that you can sign up for and participate in. If we're ever reviewing, updating policies, creating new policies, you can be a participant in that. As far as the legislation, the way to go is talk to your MLA. If there's any legislation you're not in agreement with, but you can appeal that through us. Is there any questions that came through with that first section?
Yes, we have a question. At what point will a decision not be overturned?
That's I mean, it just really depends. And this might answer your question as we go through the levels and what the actual appeal process looks like, what the team level reviews look like. But we do have, I'll just bring up this next slide so you can see this. So if this doesn't answer your question, just let us know. But that initial level, if you're not in agreement with the decision, is to contact the person that made the decision. So the adjudicator typically, or the case manager. Call them hopefully before the decision's made. They've gone through the rationale, the policy, the evidence they've considered. There's a letter associated with those decisions as well. If that doesn't help explain it, call them. They'll go through it with you in more detail. If that doesn't change the decision, you do have 1 year from the date of those decisions, though, to start the appeals process. So keep an eye on the date of that letter where that decision is made. If you are outside of that time frame, it's a little bit more difficult to get that appeals process. You'd have to write to the chair of the dispute resolution and decision review body to explain why you're appealing outside of that time frame. But yeah, best to just keep track and make sure that you're appealing within that 1 year. If the decision's upheld by the person who made the decision, the next step is to talk to their supervisor. Talk to them. That is the next step. You can do that before you submit your formal request for review or after. That's part of the process. But typically, if you request it before, you might not have to fill out that form and start the process. The supervisor might have different information for you. They might say, well, maybe there's missing information, or we need to send for some more medical assessments, whatever it might be. You might have new information to provide that we weren't aware of at the time the decision was made. So that's best to talk to the supervisor then. If the supervisor says, no, I agree with my claim owner's decision, then that's when you would start your formal request for review process, and you'd fill out what's called a request for review form. The number there is G040. So if you're looking for the form on our website, you can just type in the search bar G040. It'll pop that up for you. You can fill it out online or fill out a paper copy and submit that in. That's going to start the formal request for review process. This is going to send a task to our dispute resolution and decision review body, or DRDRB, another acronym. I know WCB is probably the most acronyms that I've ever seen, but that starts it with them. It is our internal review board, so they do work for WCB. They're going to take a look at everything on the file. They're going to set up some time to speak with you to talk about why you disagree with the decision. They can kick it back to the case manager or adjudicator if they feel like more work needs to be done. to reconsider the decision. So again, more medical reviews, missing physical demands analysis, ergonomic assessments, whatever it is, conversations back with the worker and the employer, or just information gathering, or they do have the power to overturn the decision at their level. If they don't overturn the decision, if they think, you know what, based on the evidence, we feel like the right decision was made at the time, then you'll have 1 year from the date of their decision. They'll send out a full report. You'll have 1 year from the date of that decision to take it to our external review board, which is the Appeals Commission. So that's external. They are under the government of Alberta. They're not under WCB, but that is the last level of appeal. So if the Appeals Commission upholds the decision, that is pretty much the end of the line. You can go all the way up to the courts of the Queen's Bench. But for this, for our appeals process, that's kind of where we stop, is there. In terms of timeliness, if you're wondering how long does this usually take, at the DRDRB level, they typically take, I think it's like 40 days, I read, that they have to review a decision and to render a new decision. The step before that, I guess I should say, the supervisor does have 14 days to decide whether that request for review needs to go forward. So they have 14 days to review that decision, call you. If they say, no, there's nothing we're going to change, that's when the DRDRB gets involved. Then they have 40 days to review that. They're going to take a look at it, contact the requester. So that would be you in this case as the employer, request a customer service decision, maybe to be overturned or whatever it is, gather more information. So that would be about 40 days. And then once it's all said and done, if you still want to go through with the Appeals Commission, that takes a little bit more time. They usually take a few more months. Martine, I don't know if you have that information somewhere. I don't have it on this slide, but I think it can take a few months for them to schedule a hearing. And you all may have some experience already with the Appeals Commission. Sometimes it can be pretty lengthy, but worth it if you can get if it's not the right decision, then we need to have them take a look at it and take a look at that, right? So here's what it looks like if you're looking through on our website for what the forms look like. That's the online process. You can fill it out, and then the paper form. One thing that I'd like to mention here, when you pull up this on our website, pull this up on our website to fill out the form, it will look similar to our employer appeals consulting service that my group offers. So sometimes an employer will, this happens once in a while, where an employer thinks they're filling out their formal request for review, but they actually filled out a consulting form. So one of us, an industry support specialist, will reach out to you. We can get those flipped over pretty quickly to the formal request for review. So don't worry if you fill out the wrong form. We won't make you fill it out again. We do have a way to flip those over to the right form. All right, next up, we'll talk more about what the DRDRB is in more detail. Again, I said it was an internal early resolution process. They have 5 days initially to reach out to you, and then a total of 40 days to come up with their decision. You can request an in-person review here, so you can meet with them in person or on the phone or video chat now, because we do that lots these days. Supervisor review within 2 weeks. And if that request for review from the supervisor is referred to the DRDRB, if the decision maker and supervisor can't alter their decision or resolve it, that's when it gets forwarded off to those resolution specialists. And that's when they'll start their process. The top 4 issues I wanted to mention here that we've received in 2024, which may or may not come as a surprise, I guess, but the number 1 issue that they receive is the acceptance of the claim. That initial entitlement decision is one of the main ones that we get through for requests for reviews. Second up would be second entitlement. So if it's accepted, say for a right shoulder injury, and then a couple of weeks later, a couple of months later, however long, now we're accepting a tear to that shoulder, or maybe the other shoulder is now getting accepted. So additional diagnosis entitlement is number 2. The third thing that we see coming through is entitlement to what we call temporary total disability payments. So what that is if someone's completely off work and we're paying them full wage loss benefits. So that's what temporary total disability means. And then 4th issue that we see coming through is economic loss payment calculation or entitlement. What an economic loss payment is a monthly wage loss supplement that someone gets if we determine they have a permanent work injury and you as the employer can't accommodate that. So they're either getting a monthly top-up payment to supplement their wages moving forward, or if they're completely not able to work anymore because their injury was so severe, then they're getting a full wage loss benefit monthly until they're 65. So that's the fourth issue that we're seeing come through, is just whether someone's entitled to that or how we calculated that top-up benefit.
Kim, I just have a question here from Amy.
Yeah.
So Amy was told from a case manager that WCB accepted COVID claims for support staff, so housekeeping, food services, at supported living accommodations under outbreak. But now it's no longer covered, and only healthcare aid would be considered for approval. Are you aware of a policy change that has happened? I am
No,
just trying to search through to see if there has
no,
been
there
any
wouldn't be a
changes.
policy change. We're still looking at it under the same policy. So if there's been any outbreak situation, or if there's multiple people that have had COVID, we would still look at it under the same policy. So I don't see it changing with the type of job that they've had. We would still take a look at that.
So yeah, I think what Amy is saying is, would this be a situation they could appeal if it wasn't accepted as a support staff? So yeah, obviously we'd have to look at the details a bit more carefully, but if this was from an outbreak and that's where the COVID was obtained, then we can definitely, it could be an appeal situation.
Yeah, definitely talk to that claim owner and the supervisor, I would suggest, as the next step, just to get that clarified. And then, yeah, you can definitely appeal that if you feel like it should have been accepted. Okay, appeals commission, what are they? So this is our final level of appeal, our external. They are separate and independent. They're a quasi-judicial body. It's a tribunal board which has powers and procedures resembling that of a court of law, and they're obligated to objectively determine the facts and draw conclusions from them, so they can provide the basis of an official action. So it's a pretty more formal, I guess, than our DRDRB process, but still not as formal as an actual court of law. But that's what they are. There's a panel of them that will review, and we're hoping that everybody would agree to participate in this process. The workers are given an option to participate as well. And just a suggestion, if a worker is ever going through the appeal process and you get contacted by the appeals commission, if you want to participate in their appeal, we always suggest that somebody from, as the employer contact, will participate in that. You might be able to provide your, you'd be able to be there and provide your side of it anyways, if there's any missing information. They do report directly to the Minister of Jobs, Economy and Northern Development. And they do represent the final level of appeal. There is something at the bottom here I want to bring to your attention under resources. So the 𝐼𝐜𝐿 website. In our longer session, I would go and show you where to find this and how to look at it, but this will show you appeals commission decisions. So if you're ever wondering, like, how does this play out? So if you're carpal tunnel syndrome is one that we usually search because it's a quick search. But if you if you bring up 𝐼𝐿𝐿 and you type in CTS, it'll bring up any appeals commission decision that has carpal tunnel syndrome in it. And you can see, were any claims overturned for this? Were they not? Whatever your situation might be that you're thinking, I want to see how the appeals commission might have looked at this. It's a great website. You can search all their decisions on there. So it's pretty neat. And the notice to appeal form link is there too. If you ever want to take an appeal all the way up to the appeals commission, the form to do that is there. Next, we're going to talk about, I guess, before you go through with your request for review, what we're suggesting for best practices and how to prepare for that and how to analyze the data and all the reports that you might get when you request a copy of the file. So first step, pretty clear, simple, I guess, is to review that decision letter that you want to appeal the decision in. Read that letter along with its rationale. We'll list the policy that we made that decision on. If it's initial entitlement decision, it'll be policy 0201, the basic main decision we use to determine entitlement on all claims. So then you can then take that policy, search it on our website, be like, does it make more sense to me now that I've read through the policy? If it still doesn't make sense to you, call that person that made the decision. The letters aren't as detailed as they used to be. So you might be like, okay, cool, basic policy 0201, that doesn't really tell me very much as to why you accepted this knee sprain. But call them, they'll go through all the evidence that they had, get them on the phone and have that discussion with them. They'll be able to provide that rationale for you. And if you have any concerns with that decision, if you feel like they didn't have all the information on file, at that point is when they can go and request more information from, get chart notes from a previous physician. Go look back further. If it's a progressive injury, did we get all the information we needed to make that decision? Do you feel like another assessment might be necessary? Did we not have the physical demands analysis or the correct one? So anything that you could provide at that time that's the time to do it. Hopefully before the decision is made, but you can always submit stuff after. If we're unable to resolve that issue right then, that's when you need to decide, okay, am I going to take this further to the next level or not? That's when you talk to the supervisor, go through the same information, and then you can decide, okay, my issue is still not resolved. I'm not happy with this. I'm going to go through with that formal request for review and fill out that G040 form. When I talk about information that's missing, so what do we consider new evidence? So it has to be relevant to that issue. So if we're looking at, say, a progressive injury for the shoulder, so it has to be relative to that initial entitlement decision. It can't be like, well, this person also, let's see, this person also, maybe does, I don't know if that actually applies with the shoulder. Let's say they ride their bike a lot, just as an example. So that doesn't really have a lot to do with the shoulder, really. I mean, it could, I guess, if we were going to get into it, maybe they lift their bike in and out of their vehicle. I don't know. But if we're looking at, okay, mainly riding the bike would be knees, ankles, hips. It's not really relative to like, why did we accept this shoulder injury? So just think about it that way. Did we have this information before? Was it already there? And, maybe we considered it, but it didn't change our decision. It has to be new information, something we didn't previously have available in order to be considered new information. Why I bring this up is because new information can be submitted at any time. Remember, the time limit to request a review is 1 year from the date of the decision. At any time, if you're beyond 1 year, but now you're like, oh, but they didn't have this piece of information, you can still submit that outside of that 1 year time frame. And if it is actually considered new evidence under this policy, 0108 part 1, then we can take a look at it and we could still change a decision if it makes a difference to how we looked at it originally. So that's why this slide is important. So at any time you can submit that. It is up to the customer service person, whether it's the adjudicator, case manager, supervisor, to determine, if this does actually meet the new evidence policy. Before you move on to a request for review, you might want to look at what is the financial impact of this decision. Is there a cost benefit for me going through all this work? If I'm successful at my appeal, what are my costs? How are my costs going to change on the file? Will it even make a change? Would I be entitled to any type of cost relief, which we'll talk about next? But this is what my group does, industry support. If you have questions about this, we can go over the impact with you. So we can talk about potentials. If this claim isn't, if you're not successful with the appeal process, here's what the impact is on your account. And it does impact you for 3 years. So if you have a date of accident claim from 2023, like this year, if you're looking at appealing, that won't actually impact your premiums until 2025. So you do have some time to take a look at it, but it's just good to know information. So if you have a decision from last year that you're looking at it, it is going to start impacting you next year. So if you have any appeals that you wanted to get started, reach out to either myself or Sanjeev Bagrath. Maybe I'll provide his contact information in the chat later on. I'm the industry specialist for continuing care and senior care homes for Southern Alberta, so including the city of Red Deer and South. Sanj does Northern Alberta, so north of Red Deer. So if you have any questions about this outside of this, please reach out to one of us and we can go through the financial impact. Some alternate remedies aside from requesting a review of the decision, what we call transfer of claims costs. So if you ever have a situation where you feel the injury was caused due to the negligence of another employer, then you as the employer will actually have to start this process. We have a form that you can fill out to request that the claims costs be transferred from your account to that other employer's account. We see a lot of these with motor vehicle accidents where, your staff member might be out going in between care homes or in between clients' homes, and they get into a car accident. If it's another worker under the act that causes that accident, let's say a delivery driver rear ends one of your workers, you can request to transfer those claims costs from your account to their account. What third-party recovery is, similar situation, we'll use the motor vehicle accident, but instead of another worker causing the accident, it was just regular person not working at the time. So maybe I was out getting groceries, I rear-ended one of your workers. Our legal department would then get involved and look at recovering some or all of those costs through litigation from my insurance to recover those costs from your claim. So that's another way to get costs relieved off of your account. And again, cost relief, we have the policies here. Basically, we can provide cost relief in certain situations if an appeal is not likely. If you talk to one of us and we're like, well, I don't know how successful you'd be at getting an appeal, but you might be able to get cost relief. So when looking at this, there could be an aggravation of a pre-existing condition. If there's anything else that delays the recovery of that compensable work injury, we could look at whether it fits some of these cost relief policies. So the shoulder example I gave before. So if I had a shoulder injury from, maybe lifting and moving patients, and now my shoulder's sore, I was diagnosed with a strain, and now that's not improving. It's been beyond the normal time frame for that shoulder injury, say beyond 6 weeks. Might be doing some further investigations. The MRI comes back, Kim has a tear in her shoulder. You look back at my medical history, I had a previous tear from playing volleyball. So, that's pre-existing, but now it's flared up and now I need surgery. So you could ask the claim owner to take a look at that and say, well, if not for Kim's previous volleyball injury, she would have probably been better in 6 weeks. Now we're looking at, it's like almost 6 months now. So you could ask for cost relief on that. For any cost after 6 weeks would then go to the industry and would be relieved off your account. So there's multiple more examples that fit these policies, but hopefully you kind of get the idea there. So it's always good to ask these questions as you're going through the claim. If you feel like there's anything that might be delaying the recovery, ask the claim owner, is there any benefit in looking at cost relief here? A reopened claim or a continuation versus an aggravation of a pre-existing condition. Why we like to talk about this is there's different types of claims coming up, I guess, or popping back up. So there might have been a previous claim, say for my shoulder, I use that same example, where I was able to go back to my full duties, my claim was closed. And now, after a couple weeks, nothing new's happened to me, but my shoulder's bothering me again. So I may ask for that claim to be reopened. And we would look at, okay, what are the connecting factors from when Kim returned to work, her claim was closed. Now she's saying she's having ongoing issues. So there's that, again, that review process where we would be gathering more information to say, can we connect the dots? Is it just a continuation of her previous injury? Or did she do something at work now to aggravate that, to make it worse? And would it be a new claim? And we could look at an aggravation of a pre-existing injury. So there's lots of things here that, again, we'd be going through in more detail in our longer seminar. But again, we'll answer any questions as they come up, and I'm always available for questions later. So if you're considering an appeal, and again, you're not too sure what policy you're looking at, how to explain the policy, if you need more help, because our policies, as you probably are aware, if you've dealt with us at all, are always gray. Nothing's really black and white at WCB. The policies are open to interpretation. You might need help clarifying things, how was this decision made? Why was it made? The industry specialist, which is the group that Martine and I work under, will be able to help, I guess, point you in the right direction of the correct issue of appeal that you're looking at and help clarify what outcome you're seeking. So why do you want to appeal? Is it because you want your costs to go down, or is it just the principle of it? Doesn't matter to you if your costs are going to go up or down because of this appeal. You just, based on principle, you want to appeal this decision. We'll talk to you about the cost relief options in that case as well. If you're saying, well, I want this whole claim denied, but really your issue is more about the wage loss benefits being paid, we'll help you kind of get more clear on what your issue is, so that when you do proceed forward with that request for review, you'll be filling out that form correctly and with the right issue in mind. We don't advocate for you in the appeals process. We're not representing you throughout the appeals process. We just give you advice on what the process could look like and what the outcome could be, so that you can make an informed decision on whether or not you want to proceed with that request for review process. So we'll just give you guidance. That's what we're here for. You can access it if you've already spoken with the decision maker and the supervisor to try to resolve your concern. Where you can't access it is if you have an employer representative or a third party representing you to do WCB claim stuff. So if you don't have a third party representing you, then yeah, we can help you with your service. The reason why we don't offer it to people who have third party representatives is you're already paying someone with knowledge of WCB and everything like that. So you should be utilizing their services. And of course, we always double check that the claim decision was made within the last 12 months. So we will tell you right then, you're not likely going to be successful with this appeal because it's outside of that 1-year time frame. And we'd be asking you, was this decision communicated in writing? Do you have a copy of that letter? We have access to the claim file as well, so we'd be able to find that. If it was just a verbal communication from a claim owner to you and there was no actual decision made, then we could assist with talking to that claim owner and saying, hey, you need to put this in writing if it's an actual decision, so that you could actually proceed with requesting a review for that. That's kind of our appeals consulting service. There's another service available to employers that's free. This is all free, of course, through WCB, but this other service here called the Advisor's Office is through the government of Alberta. They have a workers advisor branch as well as an employer advisor branch. This is also free, but they are, oh, my bullets are wonky there. They are independent from WCB. Wow, I really did a job on that one. Okay, so they're independent from WCB. They have knowledge and experience with WCB. So a lot of them used to work for WCB. So they have a lot of claims experience, employer account experience. So if that's your issue, they have a lot of knowledge there. They understand our legislation, our policy, our processes. So if an employer requires assistance with a claim or account related issue, you can use this service. They'll also provide support, advice, education, and will actually represent you throughout the appeals process. So I know a lot of you are super busy. WCB is like this much of your job, but sometimes it can take up a whole lot of your time. So if you need help with an appeal, going through the advisor's office might be a good way to go because it's not going to cost you anything. And they'll do all the legwork for you and they'll actually represent you throughout the whole request for review process. Here is their contact information. So you'll have their email address, phone number, as well as their website is really good. They have a lot of information on there and you can reach out directly to them to get that started.
Kim, we have a question here. So are you able to explain the change in the Cut-in Red Tape Act regarding limiting presumptive coverage for psychological injuries?
Not in this forum, but if they wanted to reach out after the fact, we can definitely have a discussion outside because I want to keep going with this request for review process. But definitely if they wanted to give their contact information, Martine, then we can reach out to them after.
Awesome. Okay, I'll grab that.
Yeah.
Then.
Okay, thanks. Now you're ready to roll with this request for review. How do you prepare for this? First step, we advise you to contact our access to information department and get a copy of the claim file. You do need to be the primary contact on your account or assigned as an authorized advisor in order for this to go through. So make sure that you have that straight first before you fill out this form because it'll just delay the process in you getting your claim file. But once you fill out the form C896, you can get a copy of this sent to you and you'll have everything that's on the claim file. So any of the documents that we have, so the medical information, letters that we've sent out, you'll have copies of the file notes. So any notes that the claim owner is putting on there to document conversations they're having between you and them, the worker and them, anybody they're talking to about the claim, you'll get a copy of all that stuff. So we recommend that this is the first step that you take so that you can have the full picture and you can organize everything. How we recommend you organize this is in chronological order so that you can put in the notes in between with the medical documents and the letters. So again, it tells the story from start to finish. When you get the file, there's going to be lots of cover pages, extra pages. It's not really going to be in chronological order. It'll be based on the data service. So you're going to have to do some sorting, but yeah, hopefully it's not a super long file. It won't take you long to sort it, but there will be probably some duplicate documents in there as well. Focusing on the internal documents from the claim owner. So the letters that we send out, so the decision letters, any update letters, medical reports that we get from our general practitioners, physios, chiros, return to work centers, any MRIs, and any non-medical documents. So that would be stuff like if we have a consultant comment on the file, so one of our medical consultants, they'll have reports on there, any investigation reports, anything like that. So those 3 things you should focus on when you're looking at what is important when looking at these files. Once you have it sorted in chronological order, what you're wanting to look at, is there objective evidence of an aggravation of a pre-existing condition in a prolonged recovery? Just so that you can keep that in mind as you're reviewing, maybe I'll request cost relief if that hasn't happened yet. So you're going to be looking for a medical consultant memo. We use our medical consultants to make comments on these things. They'll review the whole file and they'll answer the questions. What was the most reasonable diagnosis based on the mechanism of injury? Could this have caused or aggravated the diagnosed shoulder tear, whatever it would be? So they'll make their comments there and give their feedback to the claim owner so they can make that decision. Are there any non-compensable factors delaying recovery? Does this person have any other conditions that you think might be delayed? So if you think of, say, a worker that has an open wound on their leg, open wounds shouldn't take more than a few weeks to, depending on how deep it is, I guess, but it shouldn't take that long to recover from. But are they also a diabetic? Could that explain why there's a delayed recovery? So we have a cost relief policy for concurrent conditions. So something that's happening at the same time as the condition that we've accepted or the injury we accepted that might be delaying the recovery. So are there any non-compensable factors? That might come up in some of the medical reports, that might come up in some of the file notes, or you might know that information already outside of the claim. So anything else, or is there a note of a separate injury, a second injury that may have happened that's now delaying the injury that we accepted? So just some things to keep in mind as you're looking through that file. Is there a suggestion of another cause for the disability? Did it suggest a trip that the person took before, or that they had this injury before? There's sometimes the checkbox that they've had an injury to the same part of body. So anything like that, that might flag a further discussion with that claim owner. As you're putting things in chronological order, are you noticing any major gaps in the medical treatment from the date of accident to that first medical, or from the first medical to the second medical? Was there a few months before they actually needed treatment? So what happened between that time? Do you need to contact the claim owner to request actual chart notes? Maybe we don't have that on the file. So just start thinking about that. What was the decision that was made? We're going to look at, was there a work-related factor? Was there an injury sustained as a result of that, what they were doing on the date of accident? And then piece it together, because now you're working backwards. You kind of know how this all played out from the time the injury happened to when we made our decision. Now you have a copy of the claim file, so you can kind of see everything in front of you. It might help you identify any gaps. Did the problems continue after they stopped working? So for your progressive injuries, so for those injuries that happen over time, there was no specific incident that caused. So if you're looking at carpal tunnel as an example, if they're saying, well, carpal tunnel is a result of me doing, typing at work or whatever it is, I have to crush lots of medication. I do lots of work with my hands, but now they're off work. Did their symptoms change? Did their symptoms improve now that they're not at work? Did they stay the same? Did they get worse? So those are all good questions to ask, because if the symptoms stayed the same and now you removed the work activity, I would be questioning probably, well, how could work have a part in that if now we've removed the work activity and they haven't gotten any better? So good questions to ask as you're going through. Are there any conflicting medical opinions? Did the GP say the person is not fit for work at all? And now we have another GP saying they are fit for work, or that the person has carpal tunnel and it's related to some other non-compensable factors outside of work, and we didn't have that looked at. So just some good questions for you to keep in mind as you're going through this information. And you might come up with some of your own depending on the case, because every case is so different. As we're looking at conflicting medical opinions, I guess I should point out, we do have different, we would have general practitioners, we could have specialists commenting on that. We may have even had a medical consultant that works for us comment on it that has a different opinion, or we may have sent them for an independent medical exam with the specialists. So we would put more weight, or the appeals commission, I guess I should say, puts more weight on a general practitioner who might have, like if it's someone's family doctor that has a history of working with that person, they know them really well, they would put more weight on their opinion versus our medical consultant review who's just looking at documentation on the file, or an independent medical exam who sees the person once for like a 20-minute assessment. So keep that in mind as well. If you're wondering, well, this person's a specialist, why wouldn't you take that over the GP? Sometimes that's how the appeals commission will look at it. Once you've gone through everything, reading the file, analyzing the evidence, coming up with your list of questions maybe that you have back for the case manager, look at it, like I said at the beginning, look at the weight of evidence and the balance of probabilities. Is the evidence equal on both sides? Like, could you say, well, there's enough to say that it would be work-related and enough to say that maybe it's not? Then again, that benefit of the doubt policy would come into play. If you can see now with everything in front of you why the evidence was weighted more so to accepting it, maybe then you won't need to appeal it at all. But if you're still thinking, no, I think this is more so not work-related, then you can start formulating your case and preparing for that request for review. And look at it from both sides. Like, try to look at it from the worker side as well as the employer side. Don't ignore any conflicting information that you come across. And always, as you're going through this information, call back to the case manager, the adjudicator, and ask those questions. Say, hey, I had the copy of the claim file. I've noticed this. Ask them the questions. They're the ones that make the decisions on the files. And they can help, direct you, or maybe that's something that they can do to start requesting some new information for you. Any questions about the preparing and analyzing the data? Okay.
No questions, no.
Perfect. Last few slides here are about actually presenting your request for review and appeal. Just some suggested presentation format. We want to make sure that you know exactly what decision you disagree with. So I'm disagreeing with the initial entitlement decision. I don't think this should be accepted. It's not work related, or I disagree, wage loss benefits were paid on this file. Make sure you have that and can state clearly what decision you're disagreeing with, along with the reasons why. Have it compared back to our act. If you're going to go back to the legislation and policies, I disagree with the decision because I don't think it meets this policy. Policy 0201 says this situation doesn't fit that. Making sure that you have the evidence, not just your own personal opinion. There's obviously relationships that you have with people that you work with closely. So you might have information that's maybe not relevant to the claim that might sway your opinion possibly, but try to avoid that. Any other performance issues that have nothing to do with the claim, labor relations issues that would have nothing to do with overturning a decision likely for a shoulder injury, but focus on the hard evidence. Try to keep it clear and to the point. And again, stating clearly the outcome you're looking for. So I would like this decision overturned. I want the claim denied, or I just want the wage loss benefits removed from the file because I don't think they should have been entitled to it. Modified work was offered. They didn't accept it. Another thing to make sure you have the right people in attendance. So if if you are the manager, if you're the claims person, making sure that you're there attending these hearings. Because if there's questions asked and the right person isn't there, something might get overlooked or you might not get the outcome you're looking for. So just making sure the right people are in attendance, especially when you're going to speak with the DRDRB or the appeals commission. That's when it's, you're in front of a panel and you want to make sure the right people are there. Okay, that's all I have for you guys. Hopefully, I'll go back to the objectives. Hopefully you have kind of I know it's quick. There is a lot of questions that this may have sparked in lots of situations that you might be wondering about. But yeah, this was just the intent of this was just to kind of give a brief overview of what the appeals process can look like, what the timelines are, how you can prepare for it, and how to participate in it. Always, if any questions, reach out to us at WCB. Martine, I don't know if you wanted to put in, if you can find it quickly, if you can just type in my email and Sanja's email. And then you guys feel free to reach out to us. Again, like I said, Southern Alberta, you'd be reaching out to me. North of Red Deer would be Sanjeev. And we can set up a meeting to chat about your account, about clearing up any policies, legislation questions that you have, or if it's a process question, any questions specific to appeals. If you don't want to fill out the specific employer appeals consultation form, You don't have to do that in order to talk to us. We're easily accessible, so please feel free to reach out at any time. And yeah, we do have a few minutes. We have 10 minutes for questions, so.
We'll just open up the floor if you'd like to.
I'll stop sharing as well here.
Sure. If you'd like to type your question in the chat, or if you just like to put your hand up and unmute yourself and ask the question, that's fine as well. Just want to take the opportunity to thank Kim for stepping in to present today, pulling together the presentation so quickly. As you know, we had hoped to have the advisor's office for the Alberta Workers' Compensation Board attend to present today, but they were unable to at the last minute. So Kim graciously stepped in and agreed to present to provide an update on understanding the request for review and appeal system. So really appreciate it, Kim.
Yeah, no problem. I guess while I have you all here, I'll tell you about an exciting new dashboard that's available. So if you have a claims administrator role in the My WCB portal, you'll notice when you go to request claim and premium reports, you can go under interactive dashboards and you'll now see an all claims dashboard. This is going to show you all the claims that are active. It updates daily. You'll see who the claim owner is, their phone number, what benefits are being paid. If there's been an entitlement decision, it'll say if it's accepted or not. And it shows you 5 years. It goes back 5 years. So it's a really great self-serve tool. It'll save you a lot of calls to our contact center, I think.
Fantastic.
There's just one more question that popped up here. So are you able to address more than one issue, for example, the initial decision and the associated costs of having an employee paid lost wages? You can definitely appeal more than one issue. I'm not sure if you can do it on the same form as, can you, Kim?
I think you can, because if it's related to the same thing. So if you're saying, well, as a result of this claim getting accepted, the associated cost because of that accepted claim you don't agree with. But again, if you're not sure, reach out and talk to us and we can help zero it out. Because if it's more so, well, we go through with you and we say why this claim was accepted initially, and it's more so the associated lost time wages, that's the decision you want to appeal. So you could say as a result of it being accepted, you also don't agree with the associated costs, but you might want to narrow down on one of those issues. It might not be both.
There any questions?
Yeah, I just pulled up the request for review form. So if the multiple issues that you have are decided in the same decision letter, I think you can put it all on the same form. But if it's if it's a totally different decision, like if at first the claim was accepted and the date of that decision was June 2nd, and then 2 weeks later that person started to receive wage loss benefits and the decision was made 2 weeks later, you would then get another decision letter about wage loss benefits being paid. So then that would be a separate request for review form for that second decision.
Okay. I think that's it for you then, Kim. Again, thank you very much. Before everyone else, before folks start to sign off, there's just a couple of final wrap-up slides that we'd like to go through. Just a reminder that CCSA is here to support you. We have a variety of resources on our website. We've been building new resources on a daily basis, and so always check back to the website. We've been very planful in scaling or scaffolding our resources to support frontline workers, supervisors, managers, and leaders in organizations. So there's a variety of different types of resources to support depending on your level in the organization. We are proud to announce that we have our learning management system fully operational now. And we have 9 free courses currently that are available in the learning management system. But we'll continue to offer virtual instructor-led and from time to time in-person instructor-led courses as well. And then lastly, for those who participate in the Certificate of Recognition program, just a a gentle reminder to register your audit if you haven't done so. For those of you who do not participate in the Certificate of Recognition program, reach out to us at the CCSA to ask about how to continue to improve your occupational health and safety management system performance by participating in the Certificate of Recognition program and the incentives that are available to you within that program. And I'm just going to hand it off to Anush from the Alberta Seniors and Community Housing Association. She has a couple of slides to walk through with you before you sign off.
Yeah, thanks so much, Dana, and thank you, Kim, for a very informative presentation. Just quickly wanted to cover, probably the vast majority knows us. We represent seniors housing as well as community housing organizations in Alberta, and we provide advocacy services as well as education and other member services. I wanted to quickly mention about our learning center, which is an online platform. If you could please switch to the next slide, Dana, which is an online training platform that provides education to frontline employees of seniors housing organizations. So we currently offer all courses for all departments, and that is required by Continuing Care Health Services Standard 9. So it's really one course format with all the training modules, and at the end of the training, the participants receive certificate of completion, which is good for 2 years. Our platform also offers lots of best practices, things like effective housekeeping practices, customer surveys, equity, diversity, inclusion, evictions prevention, and much more. And we do offer reports and multi-level access to administration managers as well as frontline employees. And what is really new at ASCHA is that besides the traditional seniors housing organizations, we currently also have an opportunity for long-term care operators as well as home care providers to access the Learning Center for Employees training. So if you are interested, you can contact me. Please switch to the next slide. Here is my contact information. I'll be happy to show you all the CCHSS required training we have in the Learning Center, as well as discuss how you can get access for your frontline employees. Do you have any questions? And I do see lots of names here who are using our Learning Center.
Fantastic. So thank you once again for attending today, and for ASCHA and ACCA's collaboration on bringing these occupational health and safety member discussion forums to you. Our next forum is scheduled in September 12th, if I remember right. And then the last one for this year will be in November. The next one will feature leading expert here in the Edmonton area, EWI Works, Dr. Linda Miller, who will be talking about how to prevent musculoskeletal injuries. And then in November, we'll have Gordon Walsh from Energy Safety Canada, who'll be sharing information on human and organizational performance, which is a new way to look at occupational health and safety. So hopefully you found this presentation informative, and you'll look to join the future presentations as well. And finally, we will look to reschedule the advisor office presentation in the near future as soon as they advise that they're able to start getting out in front of employers once again in Alberta. So thank you once again.
Thank you so much, Dana.
Thanks, everyone.